You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Will the real inventor please stand up? Please stand up. Please stand up. Hello and welcome to the Patenting for Inventors podcast, episode 84. Will the real inventor please stand up? Determining inventorship in a patent. I bet that most of you didn't know that Eminem's original version of Slim Shady was about inventorship and patent law, but at the last minute, he thought that maybe it wouldn't be as successful as a rap, so he changed it to Slim Shady. Now, luckily, I found a copy of the original, and even luckier for you, you heard me rap it. My name is Dr. Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com. That's D-I-A-M-E-N-T, patentlaw.com, or call me at 424-281-0162. In this episode, I'm going to talk about what counts as being an inventor for a patent. Inventorship is different than ownership of a patent, and both are really important, but you need to figure out who the inventor is or who the inventors are. You might have lots of people that are working on a product, but is every single one of them an inventor? Not exactly. If you came up with an idea, but you didn't know how to put it all together, and you worked with an engineer, and the engineer is the one who was able to make your product work, is the engineer also an inventor? Perhaps. And this matters a lot because by default, the inventors are the owners of the patent unless they assign their rights. So you don't want to have a big mess thinking you own all of your patent, and then all of a sudden you find out that someone else is claiming that they're an inventor and they also own the patent. And it could cause a real big mess. So we want to take care of these matters to begin with. I want to say first that you can't negotiate inventorship. Now, what I mean by this is that either someone is an inventor or they're not. If they're an inventor, they'll be listed on the patent as one of the inventors. If they're not an inventor, then they won't be on the patent. You can't say to someone, I know that we worked on this together, but I'll give you $10,000 if you just let me list myself as the inventor, and you're not the inventor. Now, you can say, I'll give you $10,000, and you assign all of your rights to me. That's fine. But they're still an inventor, and you better get it right before your patent issues, and preferably even before you file the patent application, or else it can be a real headache. Now, it's not so much of a headache to change the inventorship on a patent, and I mean that is one headache, but it's not the major one. The headache is when a patent issues, and you want to take an inventor off, but that inventor refuses to agree with you that they should be taken off as an inventor, and that's a real battle that will have to go to court. So what you have to do in order to be considered an inventor for a patent, the definition is actually spelled out. It's in the Manual for Patent Examining Procedure, 2137.01. But just because it's spelled out, it doesn't always make it easy to implement. And I'm just going to read the definition. It says the threshold question in determining inventorship is who conceived the invention. Unless a person contributes to the conception of the invention, he is not an inventor. Now that comes from a case called Fears v. Ravel. And it does say he because in that case the inventors were men, but obviously it doesn't have to be. You can see that conceiving of the invention is the main point. But what does conceiving of the invention mean? Conceiving of the invention is actually a little more than just coming up with the idea. There's another case called Hypertech Inc. v. monoclonal antibodies. And in that case, they defined what conception means. They said, conception is the formation in the mind of the inventor of a definite and permanent idea of the complete and operative invention as it is hereafter to be applied in practice. So not only do you have to have an idea, you have to have some type of plan to create the invention. Now remember the avocado splitter, pitter, and slicer I've talked about? The initial idea that you thought of is there has to be some kind of device that makes it easy to make multiple slices of an avocado really quickly. You know, that's a great idea, but that's not conception yet. Conceiving of the invention would be conceiving of a single device having different parts. One part splitting the avocado open, second part can remove a pit easily, and the third part having a multi-blade section to slice the avocado into multiple pieces. Now, maybe you haven't worked out all the details yet, but you've at least conceived the invention. And the next question that maybe you're asking is, what does invention mean? Is the invention the actual product, or is it something more than that? Remember when I talked about the claims of a patent, and they're the most important part about the issued patent because they define what your invention is. In order to determine who the inventor or inventors are, you have to read each of the claims. Then you look to see who conceived of any part of that claim. If someone conceived of any part of that claim, then they're an inventor. It's also helpful to look at who's not an inventor and what the inventor is not required to do. The law says that the inventor does not have to reduce the invention to practice. Now, reduce the invention to practice is just a legal way of saying physically making the product. So if you conceived of an idea, but you're not an engineer, but you told the engineer about your idea and the gist about how the whole thing would work, even if you didn't know the materials to use and exactly how it would be put together, you are still the inventor. Now, what about the engineer? Is the engineer also the inventor? It depends. Did they conceive of any part of the claims? And this depends on the situation. Maybe you went to the engineer and said, I have an idea for a new avocado slicer, and it has a splitting blade and a part that can remove the pit. And then the engineer said, that's a great idea. How about we add a part to the device that can also slice the avocado into multiple pieces simultaneously? If what gets issued as the patent has that part that the engineer thought of adding, then the engineer is also an inventor. You're considered co-inventors or joint inventors. If you came up with all three parts yourself and the engineer just helped out with picking the best materials, the type of metal, the spacing of things on the device, the colors, and things like that, then the engineer is not likely to be considered an inventor. It also doesn't matter if the conception to the ideas came at the same time. An invention can have many conceptual points that occurred at different times. As long as there was some kind of collaboration between two or more people, and those two or more people each conceived of some part of what later became the claims, then they're co-inventors or joint inventors. Sometimes it can be difficult to separate things out when there's a team effort and determining who came up with the conception of the invention, especially if the team members were under the direction or supervision of conceivers. If the team members are conceiving of ideas that end up in claims that get allowed, those team members are inventors. But if the team members are just technicians going through steps to make someone else's conception into a product, then those people are not inventors. And this is sometimes hard for scientists to understand because it's not the same as who gets to be an author on a scientific paper. Lots of times technicians and anyone who worked on a project is added as an author to a paper, but that's a different standard than inventorship. Another issue that people can get a little bit frustrated with is that it doesn't matter how much someone contributed to the conception of the invention. If there's any conception, then they're an inventor. There's nowhere to put on the patent that Inventor 1 invented 95% of this and Inventor 2 only invented 5% of this. Now, once you're an inventor, all the inventors own the patent jointly. Now, you can have some type of assignment that the second inventor signs and gets a smaller amount of money for their contribution, but as default, each inventor equally owns the patent 100%. Now, you might think that's weird that I said they equally own the patent 100%. Why don't they equally own the patent 50%? And this is really important and why it's so important to get patent assignments and contracts done quickly. If there are two inventors, each inventor has the right to do whatever they want with the entirety of the patent. Let's say that Bob and I are co-inventors on a patent. Bob can license the patent, go into an agreement with someone else where just he, Bob, and this other party go into a licensing agreement for $1 million. They would not have to pay me anything because Bob owns 100% of the patent. Now, it doesn't seem fair, but that's the way the law is. And to prevent this, a couple things could have been done. I could have formed a company with Bob, and Bob and I each assign our share of the patent to the company. So when the company makes money, it's split between the owners. However, the company profits are split. Maybe the company splits the profits 50-50. Maybe it's 90% to me and 10% to Bob. It's whatever the inventors want to work out. The other thing that could have been done is that I could have bought Bob out and said that I want him to sell me his interest in the patent for $500,000 so that I am the only one that owns any interest in the patent. There can be all kinds of tricky scenarios that occur. Let's say that when the claims were first written, two people had come up with the conception of what was first written in the claims. But then during the patenting process, some amendments had to be made that changed the claims and took out the parts that the second inventor came up with. What happens there is that you have to, not that you're just allowed to, but you have to change the inventorship on the patent because the second inventor has no longer conceived of the invention as the claims were finalized. There are all kinds of weird things that can happen, so it's best to consult a patent attorney if you have any questions regarding inventorship. And if you want help with your patent application, trademarks, copyrights, responding to rejections, appeals, or anything else related to your invention, you can contact me directly through my website at diamantpatentlaw.com. That's DIAMENT, patentlaw.com, or email me at adam@diamantpatentlaw.com, or call me at 424-281-0162. I'm Adam Diamant, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com, or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.